Thank you very much.
Next up, we have Dustin Zarni, Elections Commissioner for Onondaga County.
Thank you, Senator. And I'd like to thank the committee and the New York State Senate Elections Committee for holding this important hearing today on the proposed New York Voting Rights Act. I believe this is an important piece of legislation. And while I share some of my colleagues' trepidation on how it's going to affect local boards, I am generally in favor of this. I need to point out that I am also the Democratic Caucus Chair for the New York State Elections Commissioner Association, and neither the New York State Elections Commissioner Association or my caucus has taken an official position on this piece of legislation. But I am here today to talk about what I believe was a detrimental decision by the United States Supreme Court to eliminate the pre-clearance section of the Federal Voting Rights Act, and why I understand the wish for New York State to implement its own piece of legislation. I've submitted written testimony, which I will highlight so we can get to any questions. And I know we have a long list of speakers that want to speak today, and it is Tuesday in New York State Senate, so everybody's very busy. I also, before I begin, will also point out the need for funding for any piece of legislation that is passed by the legislature. The state board is a tremendous resource for all of our 62 counties of local election boards, and their funding levels that are in the current executive budget for their current mandate is not enough. And we are asking them to shoulder the burden on online voter registration and automatic, hopefully, voter registration in the near future, but also the campaign finance portion of our enforcement is all burdened by the State Board of Elections now. And they are in need of funding, not just for this piece of legislation, but for every piece of legislation that has been passed, because they shoulder the burden for a lot of our local counties. As Executive Director Brem said, a lot of our local county boards don't have a lot of staff. The smaller boards may have as little as 4 staff and only 2 full-timers. A board like myself, which has 300,000 registered voters, we only have 28 staff. So, I'm sorry, we only have, my office is gonna get very mad at me. We only actually have around 14 staff, and then we have some part-timers that come in around election to help out as well. So, putting the burden on local boards to shoulder a lot of this, a lot of times we lean on the state board to give us guidance, to give us standard operating procedures, to come up with resources for us to be able to plug into. So making sure they are properly funded and funded to the level that will exceed their mandate is important. I am generally in agreement with this legislation, because I believe it sets up a framework where we can adequately give avenues for voting rights activists and boards of elections that may be in disagreement to have an arbitrator that is maybe not the court system, or a streamlined path through the court system that could eliminate costs and money. Right now, which I am a proponent of, the current New York State electoral system, the way we handle and administer elections is, I think, a model for the rest of the country. Our bipartisan commissioners have to come to agreement, and most of the time are able to put ideology aside to benefit the will and need of the voters. But there are times where they are in disagreement, or sometimes they come up with something that is, not is not, acceptable to the voters that they serve. And having a system in place that could give a better and more streamlined approach to how to arbitrate those decisions is important. We did see with early voting last year, some counties went well above the minimum, some counties did just the minimum. We saw that, issues with counties keeping early voting centers outside of urban voting centers. Right now, we have a deadline coming up on March 15th where we are going to be setting our early voting sites for the presidential election. Most likely, those will be the early voting sites for the general election in most cases, in most counties. There is no clear plan in place for if there is a disagreement at the board or a disagreement amongst the populace. And having a set of guidelines and perhaps the Attorney General as an arbitrator before it goes to court, before it goes to judges that may not necessarily know election law, may not have studied this, may not have the time. We've had court cases that go well beyond their minimums. I had a court case in Onondaga County in 2018 that delayed the printing of my absentee ballots for weeks while a judge waited for a law clerk who was sick to come back and write a decision. And even though they were supposed to write that decision within 1 day of hearing, of the hearing, because it was so late in the calendar, that judge decided not to do that, and that delayed and cost our board a lot of money. And it was in a dispute that our board had no part in, but it was because it was a dispute that other parties were a part of. So it's something that, the new calendar makes some of these things go away, but I would like to explore this as this law evolves and as this law is discussed. I do want to stress that while the law is effective immediately, some of the enforcement actions are several years down the road. And while we look at that, if this law is to be passed, is having a cooperative, discussion with the local boards, with the state board, with the New York City Board of Elections on how they could work with the Attorney General or whatever authorized body to help bring in a streamlined system so that the burden on the local board is as little as possible. But I've submitted my written testimony, and I'm willing to take any questions on this.
Thank you, Dustin, and thank you for your continued working relationship with the legislature. I'm going to thank you for the work that you do in implementing the changes that we've made. I'm hoping you can speak to, you mentioned in your oral testimony, but also in your written testimony, the notion of disagreement with commissioners and how you feel that the Voting Rights Act, the New York Voting Rights Act, might assist in that process. So I'm hoping you can speak to that. But before that, I would like to recognize that we've been joined by Senator John Liu and rejoined by Senator May.
Senator May. So currently, if there is a disagreement amongst commissioners, there are some statutes where if commissioners disagree on counting a ballot or counting a petition, then the tie goes to the runner, so to speak. It's assumed valid. So if there's not agreement by both commissioners to throw something off, then it's assumed valid, and it's up to the parties to go to court to get that overturned. But where there is disagreement on polling places, early voting places, there isn't really a great guidance of where to go. Now, I have to say, I believe in the bipartisan elections commission structure, because most of the time we do come to agreement and we are able to come to some kind of agreement. But we also do serve the parties that nominate us and the legislatures that appoint us as well. And sometimes those outside factors come into play. And without a clear path of how to resolve those types of disagreements, sometimes solutions come about that may not necessarily be the best for voters. There's great amount of pressure to resolve that at the board level. And I agree with that pressure. It should be if it can be, but sometimes it can't be. And sometimes we need an outside party. And there is a fear of costing our host counties money by fighting it in court, or a fear of even a path to doing that before statutory deadlines come about that will disenfranchise our voters. I mean, my local board has to decide. We're meeting tomorrow to decide on our early voting sites for presidential election. I believe we have an agreement in place, so that's good. But if we did not, then I would have to institute a lawsuit before March 15th against my counterpart to change or move sites around or whatever. And that is a hard burden on a local board to institute, especially many of us are not lawyers ourselves. We then would have to go to our county law department. Our county law department is supposed to serve both commissioners, so then they have to decide, whether they're going to get outside attorneys. This is an arduous process to go through that. So it's reserved for the most grave of situations. But if there was a different process in place, and I'm not so sure that the current legislation actually provides that, and maybe that's something that could be worked in to another form of this legislation or a chapter amendment, because there is no path in the current legislation for if commissioners disagree. But setting up some kind of expediency within the judiciary or an outside body like the Attorney General to on some of these issues could at least provide a framework in the future for addressing that type of issue.
Hi, Dustin.
Hi,
Sorry
Senator.
I missed your testimony, but I had one question on your written testimony where you say that this Voting Rights Act could serve as an avenue for voters to properly address decisions made by elections boards they disagree with in a cost-effective and efficient manner. Can you talk about what you mean by cost-effective and efficient there?
Well, anytime any decision is made by the board, the only way to overturn that at this point is to go to court. And that's just costly for many public advocates groups, for many campaigns, for whatever, for the voters in general. And it's also a labyrinth of a process many times that people don't understand. And then, of course, many times once they get through the process, they've missed serving deadlines or whatever, and their cases aren't even decided on the merits, they're decided on arbitrary rules. If there was a pre-clearance section, for one, many of these decisions would be handled before it got to that point. The safe harbor provision that was mentioned earlier, if perfected as what the state board has suggested, could serve to do that as well, so we could prevent some of this legislation or some of this litigation. But also, again, if there is a set of guidance of what, if there's precedent set with other cases throughout the county in some of these things, some of these arbitrations or some of these streamlined court cases, then that could also prevent bad decisions in the future, because we would have more guidance and more precedent set, and we'll be able to have that on our internal deliberations as well.
Thank you.
Dustin, thank you very much for your
Thank you.
testimony. So next up, we are going to have a panel, a panel of two. Round of applause. A panel of two, and that will be Michael Pernick of Paul Weiss and Perry Grossman, Senior Staff Attorney, the Voting Rights Project at NYCLU. And if any of you know Perry, the New York Civil Liberties Union. If any of you know Perry, you know this will be a very subdued testimony.